Good afternoon, everybody. So we are here to talk about building transnational corruption cases. And before I introduce this really fabulous panel, I just want to by a show of hands to see how many of you have actually worked on a transnational case. Oh, okay, so there are, okay, all right. So let me just start all the way at my left. Evan, I can either, if you would like, I can either sort of read your bio, or if you'd like, you could just give a few words about your background. Say yes.
Bren wants you to read everyone's
He wants me to read everyone's bio?
verbatim, I think, yeah.
I think we'll pass on that, Brendan.
You want me to do it very quickly?
You could give a very quick...
I can do yours.
Everybody up here has known each other a while, but why don't you just give a few of your highlights?
I'll do it very quickly. So thanks very much, and thanks for having me. I work at Cravath, Swain & Moore. Until 2 years ago, I was an assistant U.S. attorney in the Eastern District of New York, one of the DOJ's prosecuting units based here in Brooklyn. While I was there, I was involved in the National Security and Cybercrime Unit, and I think of particular relevance to this conference and this panel, I was involved in the FIFA case, a transnational corruption case. So I was there for 10 years and moved to a law firm about 2 years ago. And so now I'm effectively on the other side defending companies and individuals, oftentimes in transnational corruption cases.
Okay. Brendan?
My name is Brendan. I was until about 3 years ago, I was an assistant U.S. attorney in Manhattan. And I also, not unlike Evan, did both public corruption work as well as some national security work. And I am now a partner at Wilmer Hale here in Manhattan.
And Nicole?
So, hi, my name is Nicole Argentieri. I'm the most recent recovering prosecutor on the panel. I've been out of government a year. I was in the Eastern District with Evan. We, in fact, started the same day for a little over 10 years. While I was there, I did lots of different types of cases. I did a couple organized crime cases that had some transnational corruption elements to it, and I was the chief of the public integrity section when I left, and now I'm at O'Melveny. And I, as Evan said, I'm on the other side, although sometimes I forget that. Don't tell anyone at my firm.
Okay, so I thought a good place to begin, since all three of you have had experience building these kinds of cases, and now you're on the other side trying to knock them down. So I thought maybe you could talk, each of you, about one or two of the cases that you built up, okay, and what some of the key challenges that you had in doing that. You want to start? We'll go in order.
Sure. Yeah, I'm happy to start. I may be somewhat general, since the FIFA case probably is the most fun to talk about, but is also an appeal. So I may generalize about it a bit, but I think, for prosecutors trying to build transnational corruption cases, I think the central challenge is, the typical grist for the mill for a prosecutor in the U.S., if you have a domestic case, is records that exist in the U.S., and if it's corruption, you're looking at bank records and other types of financial records that are in the U.S., and you have the subpoena power, so you can go get them, and witnesses that are in the U.S. You have a lot of tools as a prosecutor to go and pursue the evidence you need to conduct an investigation and to build a case. When you have a transnational case where you have a significant part of what you're looking at overseas, whether it's records or witnesses or targets, it certainly poses significant challenges. And I think just sticking with the records piece of it, the most significant challenge is the conventional way to get records abroad is through treaty requests, mutual legal assistance treaty requests. And those, especially to U.S. federal prosecutors, are I think considered fairly cumbersome tools. They work, but they can take a long time, and so they're inconsistent with the idea of being able to sort of command your case and move at the pace you'd like, because if you want to get a bank record from another country, pursuant to a treaty request, you've got to first work within the U.S. system and work with Maine Justice, the folks in DOJ in Washington, to submit the request to another country, and then you've got to wait months or even years for whoever receives it at the other end to give you the records that you're looking for. So pretty big challenge, and so I would say that the way over the last sort of half generation, I think prosecutors have tried to change that and deal with that is not to abandon those cases, but to sort of take on this idea of a sort of distant bureaucratic process and make it more personal. And so certainly it's something I did when I was a prosecutor, and I know lots of folks here and throughout the department. Things that they have done are, travel, right? Go to another country, try to, rather than send an MLAT request for records cold, go to the other country, meet with the folks in the central authority, the authority that will receive your request, and try to talk to them about how you can tailor the request so they'll actually respond to it and give you what you need and do it quickly. That's, I think, a method that can speed things along. There's peril in that. The more sort of personal you make cases, you raise the possibility that other people in other countries will get interested, right? And that means if you have a covert case that you think you're running quietly and no one knows about, if you go visit another country and talk to them about it, it might end up in the newspaper. Or perhaps more typically, if you're trying to get another prosecutor that's somewhat of a peer interested, so that when the formal request comes in, they help respond and respond quickly. If you get them interested enough, they may want to take it, right? If it's a transnational case, sort of by definition, what you're articulating when you're making a request is what the connection is of your investigation in the U.S. to that other country. And in a sense, you're articulating why they should have an interest in it. And so there are real challenges that come with sort of entering into this space of interacting at a more significant level and at a more personal level with foreign colleagues. But I think, as an overriding sort of feature of building transnational corruption cases, this is really it. Not just sitting back in the United States, sending things abroad and waiting for them to happen. It's starting to figure out how to move the sort of wheels of these international mechanisms to make things work.
All right. So let me ask Brendan if you've had a similar experience in the difficulty in obtaining, we'll use documents for a minute, and then we'll talk about witnesses, which I think becomes also very challenging in a foreign case. But do you have any particular examples that you can share with us on how you were able to shave some time off that you might, that Evan just spoke about? And also maybe you could talk to us a little bit about how you deal with the bank secrecy laws that can be so strong in some of the other countries.
Sure. I think Evan obviously hits on a number of important points. I think, one of the tried and true ways as you're leaving your office and you're flying out to on site, so to speak, is really part of this is attempting to earn advocates, earn advocacy on your behalf within foreign governments, within foreign agencies, to get them to invest in what you are doing, so that they view the relationship, they view the case in many instances as a partnership. We have had instances both with respect to documents, with respect to witnesses, and also with respect to defendants in the course of extradition proceedings. Criminal cases are great for prosecutors. The pieces of paper that you file don't really mean much if there's not a defendant that ultimately arrives in court. And so extradition is obviously a key tool for that, and that process very much can get corrupted in various ways while you're awaiting a defendant's arrival to the United States. And I think similarly with respect to documents, I think that one of the sensitivities with respect to document requests, however they are made, is how are they going to be handled by the United States? Are they going to be handled with the level of discretion that the foreign government would handle them with? What uses are going to be made of them? And is there going to be any blowback on the agency, the individual agents or prosecutors on the ground who are making these decisions and sharing these with you? What is the potential political blowback on that? And so much is perception as much as it is reality. And I think that goes back to this idea of ensuring that you're spelling out your case, your position, your potential arguments, understanding exactly what a trial in the case is going to look like, so that you can, with credibility and confidence, articulate to your counterparts, here's exactly how we intend to use these. And that, of course, also makes your arguments, it tends to make them more compelling. Here's why we need them. We're not just being greedy prosecutors, which oftentimes we are, particularly the two offices represented on this panel. We want everything we can get our hands on at all times. But I think when really push comes to shove, to make that happen, to overcome limits with respect to the Bank Secrecy Act, other internal agency protocols or policies where they will say, we have never shared this kind of document. We have never shared an interview memo. We have never shared a memo of this sensitivity with a foreign counterpart. Why should we make an exception this time? It is at that moment when you want to try to be able to articulate to them why this isn't just about your office's individual interest, DOJ's interest. There's a broader interest here at stake. And obviously, if you can discuss with them ways in which you can assist them in getting documents for certain of their cases, that's obviously all the better. But I think, with respect to one case in particular, where we had, as I referenced before, an instance where an extradition proceeding was getting corrupted. Our office was attempting to extradite a defendant. It was clear that bribes were being paid at the defendant's direction to various decision makers in the foreign country, and this ended up going up fairly senior within the foreign government, and it turned out to be essential that we had really developed a partnership with arguably sort of one of the most senior law enforcement figures in that government, who was able, in effect, to speak truth to power at the appropriate time and say, this is not how we want this all to go down. This is not worth it for this case. And he essentially forced some in that government to have a backbone when they didn't think they really needed to. So again, that's not directly responsive to your document question.
No, but it goes much broader. And I think one of the things that you're talking about, and maybe I'll ask Nicole to address this, is throughout the process, and both you and Evan have talked about this, the need to express to foreign, governments, both law enforcement and in politics, why it may be in their interest to be cooperating, and yet try not to get them either so interested that they want to basically take it from you, or interfere to the point of corrupting the process. Sounds like it happens at the beginning of these cases. And I wonder, Nicole, if you could speak to your experience with that. So
I think, in my experience, two things are important. Number one, you've got to give a little to get a little, and two, it's really about relationships. So I did two sort of international sort of drug trafficking cases that one involved Italy, Costa Rica, and the United States. And it was kind of fascinating because this little pizzeria in Queens, the owners of it had ties to organized crime in Italy. And they had a really big extortion racket in Italy, and they were funding the importation of like 40 kilograms at a time of cocaine from Costa Rica that they were hiding in cassava crates and like sneaking into US ports. And we picked it up through a cooperator here, and went up on a wire and got these really interesting intercepts with Italy. And a lot of the activity, though, in a transnational case is taking place in the other country, right? And so there were going to be these meetings that we wanted to cover in Italy. And we also needed some information about where people lived to sort of back up our wiretap. And what we decided to do, because we had really good relationships, that's why relationships are important, were to contact prosecutors we knew there and say, do you want to do this together? And it was a leap of faith, right? Because we gave them, with the right permission, some of our intercepts so that they could get up on their own wires, which ended up being honestly the best calls that we had in the case that we brought down. We ended up arresting 3 people here and 1 person from Italy who was never extradited, and I think they took down 15, okay? And we seized whole shipments coming from Costa Rica, and there were surveillances in Costa Rica. It was 3 different countries sort of coordinating together. But, and for someone who I really like to keep control over my cases and who knows what, it was a real leap of faith to say, I'm going to sit down with you, I'm going to tell you what my case is about, I'm going to give you some of my evidence, if you give me yours. And the tension that was going on when we were supposed to have this wiretap exchange, they wouldn't send it. They were like, you send your line sheets. Like, it was just crazy. And I was like, please. And we ended up sending ours first, which if you know me, I would never do, but I did. And it worked out, and they sent their evidence over. But to be honest with you, I really pride myself also on being like an act fast prosecutor. Like, I'm like, let's just go. The other thing you have to do in these cases is really think about how it's going to play out and understand the system on the other side that you're working with. Like, they were going to make arrests in Italy. To make an arrest in Italy, you actually have to turn over a bunch of the evidence in this prosecution memo to a judge before they get the arrest warrant. Whereas here, an indictment can be like 4 sentences, right? And then the defendant gets the evidence down the road. Maybe you don't give up your cooperators. So there was a lot of planning and strategy about the steps that we were going to take once we knew it was going to be a joint takedown. And so, that's just a little bit about my experience, but I really think it's about getting to know people in the jurisdictions where your case is going to go and finding people there that you can work with that can also tell you the inside politics of where they are. Because a lot of times it's line prosecutor to line prosecutor, and you're really just trying to pull the strings of all the people above you who want like a bigger press release, or they want it to happen in a different time frame. And it's getting together with those people on the ground.
So that's very, very interesting stories. I think all of you have fascinating experiences here. But I think one of the things that you've talked about are the politics, both here in the United States that you have to manage and in the foreign countries. Can you speak a little bit to how you were able to navigate it here in the United States and the extent to which you had to, if at all, explain what the interest was of the United States in the case you were ultimately bringing?
Sure. I think it's an interesting challenge in these cases. There are people often kind of lump together this idea of the U.S. and its overseas reach by talking about it as if it's all about extraterritorial cases. And legally speaking, that's not really right. There are, a number of statutes that federal prosecutors can use that are extraterritorial, and those are, for example, things like terrorism statutes, where the entire premise of the statute is a U.S. prosecutor can prosecute someone abroad for conduct abroad because Congress has said that's permissible because of the particular type of case. By and large, certainly in the corruption arena, the applicable statutes aren't extraterritorial. They are what the Supreme Court over the last few years has taken pains to clarify are statutes with only territorial application. And so there's this very interesting question that arises next, which is, okay, it's you have a territorial-based statute, but you have a transnational corruption case. So the question is sort of how much overseas conduct, how many overseas meetings, how many overseas defendants and targets and witnesses can you have, and that is in a way, in a prosecution that's still consistent with it being a domestic prosecution. And some part of the answer to that question is a legal one, and courts are sort of struggling through that right now, trying to find out where that line is or should be. But part of it, to really get to your question, Karen, is more of a is more of a discretionary matter for a U.S. prosecutor, which is how far can you go on a domestic application of a corruption statute before it starts to be seen either by U.S. judges or by foreign counterparts as too far, and there are no rules about how you take that into account, but it's an important thing to take into account because if you go too far, a number of things can happen, right? If you go too far, you can have foreign counterparts that you're trying to get evidence from push back and say, we're not going to help you. That thing that you're describing for us, those records you want to get, that defendant you want to extradite, that's our case, right? We're not going to give that to you because while you may formally have jurisdiction, the balance of everything you've described to us really has happened here. This has happened in the UK recently. A couple of times last year, they denied a U.S. request for extradition, not because they didn't agree that the U.S. had jurisdiction, but because they thought they had more. So, one thing to take into account in how far you stretch it is how your foreign colleagues will react. But part of it is also just thinking about the sort of proper extent of stretching U.S. law. And I think that's one of the toughest questions. Certainly as a prosecutor, as Brendan said, your instinct is to be aggressive and to push hard and to push far. But the more interaction you have with your foreign colleagues, that starts to instill in you, I think, some awareness of countervailing interests and a countervailing perspective that really comes from knowing them better and knowing how your foreign colleagues view things. And certainly if they're willing to take on some portion of a case, and sort of prove that it's not just the U.S. that's engaging in the investigation and prosecution, I think that also helps things considerably. So a number of observations in response to your question, but it's an interesting one.
And what about you?
I think in many ways corruption here in the U.S. Is good business in other countries. It's just the way things are done. And so unlike, for example, national security cases, other types of crimes that are universally agreed upon are violative of certain norms and laws where you don't really have to feel like you're going to have to sell anyone, either at main justice, in the intelligence community, for example, here in the U.S., that may have equities in even corruption cases, or obviously foreign counterparts. Corruption is a bit more in the eye of the beholder, and so I think one thing that oftentimes there's no reason to talk about, that prosecutors often don't talk about, but which they spend a lot of time working on, are the cases that you couldn't bring because you couldn't get approval. Because as you tried to spin out the narrative and you tried to explain to the folks who approve these cases, both within your own office as well as down in Washington, well, how does this play out? You may think this is the most gross abuse of power you've ever seen, but the folks who are going to be on the receiving end of these document requests or are going to be asked to coordinate in the arrest are going to say, we don't see it. This is all political. This is the U.S. Sort of altering the definition of corruption to suit other needs. So I think your question is a good one in the sense that you really do have to think from A to Z on these cases as early as possible and think about how are you defining the narrative of the case, again, not just to the jury, but internally to those who, that's in many ways the more important and immediate narrative that has to be defined in as compelling a way as possible. Because if you can land in the right place there, then as we've all been talking about, you can then make the most compelling case overseas in terms of getting buy-in.
Right. I'm going to put a hold on that jury point because I do want to go back to that. But let me ask you, Nicole, what your thoughts are on that.
I think the question is just because you can, should you? And I think, as a prosecutor, I always thought no one was in a better position to bring a case, than me, our office, the U.S. There isn't, I don't think, a ton of faith that if someone else does it, it'll get done right. And I wonder if that is sort of changing. You look at the 1MDB case, which Joe Lowe, our international man of mystery, and that's a case which spanned many different jurisdictions, right? It was like corruption in the Middle East, corruption in Malaysia, corruption in the U.S. And there, we have one part of the case in the Eastern District. We have Joe Lowe, we have some former Goldman people, but yet, like the corruption charges, the sovereign wealth fund of Malaysia was just looted. Those charges against that prime minister are in Malaysia. And it's not something that that I'm aware of that we tried to take or tried to do. And so I wonder if there's more of a recognition that other countries are stepping up, certainly the SFO in London, and they can sort of cover their own areas and, have us take a more targeted view toward our own interests.
So before I turn to a few specific questions, which I really would like to ask about some of the evidentiary challenges, deposing witnesses and things like that. I do want to ask what thoughts you give as you're building these cases into what a jury may think about a foreign corruption case being brought in the United States, and the degree to which you feel or talk about at the beginning, and this is touching really, Brendan, on what you were just saying, that you're always looking at that nexus to the United States right from the beginning. Can I hear from you on that?
Sure, and I think certainly you do. I think the importance in one of these foreign corruption cases of establishing not just jurisdiction but venue, and knowing that if you're to bring the case, it's going to survive different types of legal challenges defendants can bring, sort of focuses a prosecutor in on sometimes relatively dry types of facts, but important ones that you imagine ultimately articulating to a jury in order to make clear why there's a U.S. interest in the case, perhaps not explicitly, that seems a bit defensive, right, but rather through just sort of approving the texture of the case. And so, bank flows and money flows is a particularly useful way of doing that. You can have a corruption scheme in which the relevant meetings happened overseas, and relatively little of the conduct perhaps happened in the United States, but if the money flowed through U.S. banks, then as a prosecutor you're particularly interested in sort of understanding every piece of that, in part not only because it's important for legal reasons, for jurisdiction and sometimes venue, but also because you imagine sort of putting that in front of a jury and essentially personalizing these banks, articulating where they are, putting a map of the country and showing where the money is moving throughout the country. And it makes, I think, a strong point, which is, yes, while there's a global aspect to the case, there's also a U.S. aspect to the case, and implicitly or explicitly a harm to the United States and a use of the U.S. financial system, which is often a very significant aspect of why defendants who otherwise probably are smart enough to know that they shouldn't have meetings in the United States, nonetheless engage in transactions that touch the United States. So I think as you're sort of building one of these, certainly you think about even if you don't have the ability to show a video of a meeting in your backyard, you take what you can and you focus very much on whatever you've got, and then try to get as many details as you can about that, so that you can convey to the jury, even if it's somewhat abstract, here's how it hit the United States and here's why you should care.
And I think what is, I think, advantageous to the government in these kinds of cases is that almost in all of them you can just emphasize a couple tried and true themes. I think the most useful one, or the most used one, is just greed. Don't worry about the nexus. There's a little bit of a U.S. interest here, but really, overall, this is just really offensive levels of greed. And by the way, there was an abuse of the U.S. financial system or otherwise. I don't know that there are a lot of juries that have given a lot of thought to there's not a lot of foreign defendants brought before New York juries who have large constituencies, those who are here for corruption offenses. So it's not, I don't know that it's something that in a lot of these cases.
A defense attorney.
Yeah, no, exactly, and I'm sounding maybe like a little bit of a frustrated defense attorney, but no, it is something though that I think matters a great deal for the courts, and it will matter a great deal, obviously, at other phases of the case, and so I think it is very important to be able to articulate the U.S. interest, but there are real questions that all prosecutors' offices in New York including state prosecutors. The Manhattan District Attorney's Office does work overseas as well, which is, in terms of the use of resources and the use of using resources as effectively as possible to protect and promote the law here in New York within their respective districts. I don't know that juries spend as much time thinking about those questions, but I think you do have to, at a minimum, establish some basic U.S. interest here. And in many instances, as we've all kind of experienced, that argument can be tougher before the case even gets into the courtroom with the foreign counterparts or others than it is once you get inside the courtroom.
Yeah, I mean, I agree. I think, look, convincing the jury is the whole ball game, right? So if you can't convince them to care, you sort of have a problem. And I remember thinking, we brought the FIPA case. It's such a big case for our office. I wasn't on the trial team. I didn't have those discussions. But one of the defenses might be, why are we here? Like, this is an amazing case. And it's all this, international corruption, bribe payments, soccer. Like, it's amazing. But why are we here? And, that's actually not a valid defense. but I think it's certainly an argument that you have to be prepared to address, because the defense is going to hope that they get some disgruntled juror who's like, wait, were my tax dollars paying for this investigation? Because they want to sort of distract, now I sound like a prosecutor, forgive me, from the evidence, right? So I think you have to have a compelling story to tell the jury and answer that question, but hopefully your other facts are sexy enough to where that's what they're focused on. Like, one of the cases that I supervised was a case involving Androgeda. I'm not saying it correctly. Evan, can you do it?
I can't.
Androgeda? Yeah, we need Taryn.
You hit it.
But which is, Italian organized crime, and all of the sexy mob stuff happened in Italy. And our U.S. case was money laundering. And, when we were sort of putting together the press memo, it was like, oh, if this one goes to trial, are we going to be able to get in all that other stuff? Because they were using our banking systems to fund this really bad drugs, and drugs might have come here, and drugs is probably what we would have said. But you are thinking about, like, how am I going to tell this story to a jury and get them to care about this crime, which might not, be the most interesting, but certainly our banking systems were used, and we have venue, and we should be here, and everyone should care about it.
So, Brendan, you mentioned a foreign defendant. Foreign defendants sometimes, play into this, and I think you were involved in a case that involved extradition. Have you all dealt with foreign defendants? Okay. Yes. As defense attorneys, which you all are now, so you've built these cases. Now you're
trying to be.
Now you have to look at them from the defense perspective, which really is requiring you to see wherever there can be a hole or a vulnerability or some place which often is a legal argument, and even technical, it can be a winning argument for a defense lawyer. What are your views on sort of, I would say, maybe even the venue issue and or sort of the constitutional aspect of like jury nullification, for instance, which is something that is probably not going to happen, to your point, if a foreign defendant is sitting there and there are no other foreigners in that jury box.
You should say something about government overreach.
That's right. Outrageous government overreach. No, that's right. Was that to me, or do you want to go straight?
Well,
yeah, sure, sure.
Brendan.
Well, I do think it's a very difficult argument from the defense side based on the way the law has evolved. Essentially, if you end up in a U.S. courtroom, there is very little that a defendant can do once you're sitting there to claim that I shouldn't be here. There are arguments you can make once you're there, but it is very difficult to nullify or reverse the fact that you are there, whether it's via extradition or arrest, having passed through the United States, whatever it may be. The U.S. law has evolved to a place where, absent really unconscionable conduct by the government, you are not you are properly before the court in a criminal case, and the U.S. has taken a very broad view of the executive branch's ability to bring foreign defendants before the court. And as Evan mentioned earlier, there are statutes with specific extraterritorial provisions
And some without.
And some
right?
without.
Like the Foreign Corrupt Practices Act.
That's right, that's right. And even in those that do not have explicit extraterritorial provisions, it is still very much in the government's interest, in the way the law has evolved, to allow for, look, if there has been a violation of U.S. law, the courts have recognized the importance of the executive branch to be able to go out and arrest defendants wherever they may be. Now, obviously, there's a lot to that process, but once you're there, it's not really the role of U.S. courts, again, absent serious government misconduct in getting the defendant there, to question why he or she is there. And that really then flows through to the point we were making, where it is really not a jury's role to question, why is the government bringing this case? Why are we here? Why is this defendant here and not being tried in his or her home country? As you can imagine, that would introduce all kinds of questions that would be beyond the role of the jury. The result is, from the defense side, you're really spinning your wheels if you're trying to spend a lot of time in trying to get your client out of the courtroom. There's obviously ways in which to get the case out of the courtroom, and you certainly want to explore and consider carefully what processes were undertaken by government officials from the inception of the case in terms of getting evidence suppressed and other relief that may be granted. But from a due process standpoint, you're not really going to go anywhere because of the breadth and the sort of strength of U.S. jurisdiction in these kinds of cases.
And you both concur.
I think Evan has a...
Yeah, I mean, I guess I agree for sure, but I guess I would take one step back and say this. From the perspective of a defense lawyer, whether you're representing a corporation that's being investigated or an individual that's being investigated, to the extent your lens on what is happening precedes charges, which often happens, especially in these transnational cases, and you have an understanding that there's an investigation because a government has reached out to you or because you've learned about it in some other way. The way in which the proper venue, the way in which the proper location of the prosecution comes into play, I would say now, as we're sort of entering this more mature phase of transnational cooperation, is, you as a defense lawyer know that one of the things, for instance, in a corruption case, DOJ is talking about with its colleagues in Europe or its colleagues in South America is the division of the spoils of the case, in effect, right? So who's going to get to prosecute the company? Who's going to get to prosecute the individuals who should? And more as countries have taken on, have enacted serious anti-corruption legislation and started to enforce it, that has brought enforcement, sort of stronger enforcement sort of mechanisms in those other countries. And what that means is, as a defense lawyer, you have a pretty good guess and can often tell that the DOJ is fighting with another country, right? They're fighting with another country precisely because the DOJ is perhaps overreaching, or at least from the perspective of the other country is overreaching, and you as a defense lawyer can really think about how to play into that, with you have a colleague, you have another defense lawyer that you have that is your colleague in the other country that is dealing with the other country's regulator, and you share information about how that's going. And one thing that every corporate defendant and every prospective individual defendant is thinking about is, if I'm going to I'd like not to get charged, but if I'm going to get charged, would it be better to be charged overseas or in the U.S.? And that's something that is a pretty dynamic process, and I would say as a defense lawyer, you're more focused on doing what you can to understand and even influence that than hoping that you get to a jury and can do something then. Because as Brendan said, it's pretty much too late if that's the point that you're thinking you're going to have some success.
So in addressing the advice that you give, without specifics obviously, to clients that come to you now who are facing investigations into of foreign corruption matters. What are the key things that you sit down and discuss with those clients?
I mean, I think coordinating your approach to different governments that are involved in the investigation is important. Like what I was sort of thinking about while Evan was talking was how does someone cooperate if there's a subject of investigation in two countries? You know, when I was a prosecutor, we sort of shared this cooperator with Canada. It was a little bit of an unmitigated disaster. It's a lot to manage. And if you have somebody who is facing like an FCPA violation or, you know, some other violation that spans conduct in two countries, and they do want to cooperate, you know, it's a very difficult situation because, you know, knowing the U.S., they're going to want to be the dominant player, and just getting everybody on board. And I don't really know that there's a good way to negotiate with two governments at the same time. You kind of have to pick one and go with it. I mean, have you guys had experience with sort of international cooperation in that way? What do you?
I think so it is a real challenge, and I think one of the real challenges when you're talking about in dealing with clients in this is getting them comfortable with making what can be extremely important decisions on extremely incomplete information. Right. You're in the dark, and very few when you're find yourselves in these situations. Both the lawyers and the principals at clients are not used to making such important decisions without complete information. That's really where you have to articulate for them in clear ways what are the known knowns and what are the known unknowns. And that can be a real challenge in multi-jurisdictional cases. And particularly when you have a DOJ background, you have to guard against your own inherent bias to want to say, well, we know more about DOJ than we do, say, about this prosecuting entity in insert foreign country. So let's play to the U.S. authorities. That may or may not be the right decision. That may just be the biased decision. And so it's understanding your own biases as you're talking to them, as well as their own priorities and their own biases in then dealing on playing fields that they're more or less familiar with.
And I think all three of you are at law firms that have offices in other countries. Is that right? Yes. So how do you basically work these cases with somebody who's actually in the other country that you're dealing with, or what is the usual way that you do this?
Certainly, if you have a case that has multiple countries investigating a client, then certainly it's critical to have counsel in every jurisdiction be able to deal with the local enforcement authority. The way our firm deals with it is through co-counsel at other firms. So if you have an FCPA investigation involving one country in South America, investigating it, one country in Europe and in the U.S., then typically we would be the U.S. counsel, and there would be a European counsel and a South American counsel who would all be, try to coordinate closely, precisely because, right, as Nicole said, the idea of trying to either interact with or cooperate with multiple enforcement authorities is very delicate and requires really quite close coordination.
And the rules on attorney-client privilege and internal investigations in a lot of countries are just totally different. And I think having someone on the ground who can tell you, in Germany, you're not going to want to put any of this in writing because maybe they won't recognize your privilege. Right. It's sort of hard to be an expert on that in all jurisdictions, and having people on the ground who do it every day and who actually have no sort of inside information about the other people on the other side in the same way you might have it on DOJ is super helpful.
Right. Should we take questions, or what would you like? Yes? So we can open it up to anybody if anyone has questions. Yeah.
With the OECD's work on multilateral mutual exchange of information, is that making a difference for you to work extraterritorially, especially within the OECD family? Although they're promoting this beyond the OECD countries, is it making a difference at all?
I personally, I don't know if you guys had any experience in that affecting a case one way or the other.
Yeah, not mutual legal assistance. I think certainly was very aware of the impact it had on countries within OECD who wanted to get in and pushing them to pass legislation or begin to enforce anti-corruption legislation to gain access to that. But in terms of mutual legal assistance, as a U.S. prosecutor, I was much more availing myself of bilateral treaties. So that's the experience I had.
You have any other questions? Yeah.
Just a question, in your experiences dealing with like blocking statutes and developing regulations like in Europe with the GDPR, where you can't get the information you want here,
Certainly could make things more expensive for clients. Because what used to be able to be emailed, you now have to send teams of lawyers overseas to review. But I think I think one advantage of it so far in our experience has been actually, and this goes back to sort of an original point that Evan made, which is the sort of getting over there point. Which is to say, by virtue of these new regulations, the documents have to stay where they were or where they are, and the lawyers have to go there. And I think, if anything, that probably in the long run is a benefit in certain ways, and it has encouraged, I think, or it has facilitated investigations in ways that it wouldn't maybe otherwise if everything was just getting shipped over to New York or D.C. or wherever.
I think you had a question in the back. Yeah.
Have you ever had an investigation where the State Department has interfered? I won't say department.
Has interfered.
Interfered or expressed the view? I do know what you mean. I do know what you mean.
Yes.
I mean, that probably goes to the earlier discussion we were having about the politics of all of this in terms of, building these cases, which I think is almost probably as much of a challenge as it is to build the evidence of your case, I would say. Yeah.
And I don't think in the times I'm thinking of it, it was a sort of a wrong, this will look bad, so don't do it type thing. It was more of a concern about timing or a concern about the propriety of a charge, but not like political in like a, like a corrupt way, is what I would say. It was more like, prosecutors really take a narrow view. Like, there's evidence, they want to charge, they're ready to do it. And sometimes, like, what DOJ will do is pull you back and say, well, these are kind of the other things that are going on, and this is sort of the bigger picture, and have you considered this? So I never had an experience where I felt like it was something inappropriate, although I probably complained about it at the time.
It's certainly not inappropriate, but I think, to Nicole's point, I think that you as a prosecutor, you understand your world, and you don't understand the broader set of relationships between the U.S. and any given country or region at a given time. And so I think it's an important voice that they express at various points in the process. At times, it can not feel particularly substantive, and it can feel like perhaps they are expressing interests that are inconsistent with what you might think the U.S.'s interests should be more broadly. But it's certainly an important voice to have, and it's not, I agree, not one that comes from an improper place. It just comes from a department that has a separate mission that needs to be respected in these international cases.
And if I could add, I thought you were referring to the State Department of a foreign jurisdiction, and that's what I was answering yes to. The U.S., I actually would echo, certainly there's a different interest, the State Department and the DOJ, in terms of how to deal with an ongoing investigation, a covert investigation. There's some tensions that can arise, but yeah, I wouldn't say interfere is probably a bit strong in terms of my experience with the U.S. State Department.
You said their unwillingness to play ball is viewed as there's no rule of law? I just didn't hear you.
Yeah.
Yes, yeah.
So, I'm sorry, I missed.
Yeah. So is it, the question was basically to the extent that there are political concerns expressed abroad, and the conclusion that
Right.
that's actually a reflection of there not being a rule of law.
Yeah, so I didn't have not sort of had that experience. If anything, when I was in government and I was interacting with other governments, they were very eager to sort of jump in and participate in the investigation. I don't know if you guys have had sort of different experiences.
Well, I think some of us, I mean, I do think we're all a little bit spoiled in the U.S., the independence of the department and the independence of prosecutors. And so I think you have to recognize that when considering your interactions with some foreign governments, particularly smaller ones, that where sometimes there isn't that arm's length relationship between political leaders and prosecutors. And I think that just, it oftentimes can boil down to individual relationships and finding that strong-willed prosecutor overseas who really wants to make this right, because prosecutors overseas have a far harder job than prosecutors here in the U.S. Many of them put their lives on the line to bring these cases, and finding one of those, finding a prosecutor like that is a real privilege when you can in making these cases. And so that's oftentimes what you have to hope for, and even the best intentioned, most talented prosecutors overseas sometimes can't overcome the kind of interference that you were referencing. But that's really your best shot.
Any other questions? So maybe, yeah, go ahead.
I just wondered if Evan could comment on the FIFA appeal and
Just give you an argument, maybe.
as a private citizen.
No. Sorry about that.
So I think maybe we have just a few minutes left that each one of you, if you have any, I don't know if I would say words of advice, but parting words of wisdom that you might want to just share in terms of these, building these transnational corruption cases. Do you want to start, Evan, if you have a word or two?
Yeah, I guess I would say, in thinking about the audience here and understanding there are folks from government and NGOs in a number of different cities in the world, I guess I would say that from the experience of having been involved in these cases during a time where the idea of the DOJ enforcing transnational corruption cases was really in its ascendancy, I would say that my sense is now we're in a different and new phase and an interesting one where the tensions that arose overseas that came from good and healthy debates about the U.S. being the dominant enforcer of anti-corruption legislation has now entered a new phase. A number of countries have passed really significant legislation, thinking about Sapin-2 in France in particular. That's one with great extraterritorial reach, in fact. And in a different vein, the GDPR is another. I mean, the U.S. would have to admire that in a sense. Once people really in the U.S. get to understand what that means, they realize the profound significance of that. It is an extraterritorial regulation that I think U.S. companies, non-European companies, are just beginning to grapple with. And so I guess I think I was mostly just as a comment, which is I think we're in an interesting phase where no longer is it the case that everyone has to sort of sort out what to do about it, this lopsided enforcement regime. We're now in a phase where other countries, whether because they were spurred on by not wanting the U.S. to have all of these significant corporate resolutions and get all the money, or whether they were offended by the idea of the U.S. being the only enforcer, or whether now in a new political era where there's just more tension between the U.S. and allies, we're clearly in a different phase. And I think it's from the perspective of I think a government enforcer, non-U.S. government enforcer, it's a good one because it means that there are a number of different voices that have tools to think about enforcement, and it's no longer the case of a lopsided relationship with the U.S. It's much more about partners and even allies sometimes on cases, and sometimes countries, OECD, other bodies sort of competing with the U.S. I think it's a good thing. It's a dynamic thing because I think it produces more ideas. Certainly from a defense lawyer, I think you have an ability to have a more kind of complicated understanding of how to contend with these investigations. But from the perspective of non-U.S. government folks, I think it's a very interesting time. And I think the more enforcement that happens outside the U.S., it essentially forces the U.S. to be more honest, to share more, to back off more, to acknowledge the equities of other countries. And I think that's at least my observation about where we are, and I suspect we're in that mode. We're going to be in that mode for quite a while.
I think consistent with that, I mean, we're in an age, I think, of increasingly brutal transparency coupled with real government cynicism. And I think there's, or cynicism about government and government actors. And I think it's, in many ways, it's an opportune time for those who are trying to address, investigate, and prosecute corruption matters. I think that it is a time where people are expecting the sunlight, so to speak, to be directed in every corner, and including within government corners. And I think that is going to survive irrespective of a particular political party or political regime in any country. And so I think that it is understanding, I think, how to harness that public sentiment, harness that demand for accountability, which is, I think, in many ways as sort of intense as it has been in modern times, to take advantage of that, to take that public sentiment and really run with it, and demand more, and to work obviously collaboratively and internationally with others who are engaged in this in a credible way, to try to take advantage of the moment, which I think is a unique one for those who are trying to tamp out corruption.
I totally agree, and I think it's heartening to see other countries step up their corruption enforcement, and to also see DOJ just, I think, being more open-minded about it and saying that they're not going to pile on, and in doing these joint investigations and these joint settlements, giving other countries a piece of the pie and really making the whole thing more efficient, right? Because you want to bring these corruption cases, but you don't want it to bring down a company or have it take up too many government resources, because there's just so much to be done. And so I think it's headed in a really good direction.